Hello everyone, I'm Julia Charlton and I'm delighted to be with you for this second webinar on Hong Kong stablecoin regulation. Today I'm going to be discussing first the anti-money laundering and counter-financing terrorist obligations of licensed stablecoin issuers, including the requirements for travel rule compliance. I'll then take a look at the process for applying for a stablecoin license, the restrictions on offering specified stablecoins, and the various offences under the Stablecoins Ordinance. Licensed stablecoin issuers are financial institutions for the purposes of the Anti-Money Laundering and Counter-Terrorist Financing Ordinance, which I'll refer to in this webinar as the AMLO, and they therefore have to comply with the Anti-Money Laundering and Counter-Terrorist Financing requirements set out in Schedule 2 to that ordinance. It's also one of the continuing licensing eligibility criteria under Section 10 of Schedule 2 to the Stablecoins Ordinance that a licensed stablecoin issuer must implement controls to prevent and combat money laundering and terrorist financing and ensure compliance with the requirements of the AMLO and all rules and guidelines issued by the HKMA to prevent, detect, or combat money laundering or terrorist financing. In particular, licensed issuers must comply with the regulatory requirements set out in the HKMA's guideline on anti-money laundering and counter-terrorist financing for licensed stablecoin issuers, and I'm going to refer to this going forward as the guideline. This sets out the regulatory requirements with which licensed stablecoin issuers must comply in order to meet the statutory requirements under the AMLO. Under the guideline, licensed stablecoin issuers are required to implement a risk-based approach in designing and adopting anti-money laundering and counter-terrorist financing, which I'll talk about as AML-CFT policies, procedures and controls. Issuers must assess and understand their money laundering and terrorist financing risks to which they're exposed and implement systems to manage and mitigate them. Issuers need to conduct an institutional risk assessment to identify relevant risks, taking into account customer, country product, and delivery channel risk factors, and must put a process in place to keep the risk assessment up to date. The results of the risk assessment and the AML-CFT systems adopted must be approved by a stablecoin issuer's senior management, and the systems must be appropriate to the nature, size, and complexity of the stablecoin issuer's business. Stablecoin issuers must have appropriate compliance management arrangements to ensure their adoption of systems to facilitate their legal and regulatory compliance and management of money laundering and terrorist financing risks. The compliance management arrangements must include, at a minimum, oversight by the stablecoin issuer's senior management and appointment of a compliance officer and a money laundering reporting officer. The board of a stablecoin issuer or its designated committee and senior management are required to have a clear understanding of relevant money laundering and terrorist financing risks and have to ensure that they're managed appropriately. The compliance officer has overall responsibility for establishing and maintaining the issuer's AML-CFT systems, while the money laundering reporting officer acts as the central reference point for suspicious transaction reporting. The individuals appointed to these positions must have sufficient expertise, and both roles can be performed by the same person if this is appropriate given the issuer's size. Stablecoin issuers must also have an independent audit function with sufficient expertise whose obligations include independently reviewing their AML-CFT systems to ensure their effectiveness. Stablecoin issuers are also required to screen potential employees to ensure the appointment of individuals with high integrity to AML-CFT roles. Ongoing role-specific staff training tailored to the responsibilities of different job functions and experience levels is required to ensure that staff can implement properly the issuer's AML-CFT systems. Looking now at the customer due diligence obligations of licensed issuers, the guideline uses the term stablecoin holders to refer to holders of specified stablecoins issued by an HKMA licensed stablecoin issuer. According to the guideline, licensed stablecoin issuers are required to treat as customers persons with whom they have a business relationship and persons for whom they conduct occasional transactions which include the issuance and redemption of specified stablecoins. In particular, licensed stablecoin issuers are required to conduct customer due diligence, referred to in the guideline as CDD, on specified stablecoin holders and potential specified stablecoin holders before issue and redemption. The guideline specifies that CDD must be performed prior to establishing a business relationship with a customer and also prior to carrying out an occasional transaction, such as issuance or redemption of specified stablecoins involving 8,000 Hong Kong dollars or more. A licensed issuer's CDD obligations are also triggered whenever it suspects a customer's involvement in money laundering or terrorist financing, or at any point it doubts the veracity or adequacy of previously obtained identification information. A narrow exception permits verification of a customer's identity after a business relationship has begun, but only where it's necessary to not interrupt business. The associated risks of delayed identity verification can be managed and verification is completed as soon as reasonably practicable. Paragraph 4.3 of the guidelines sets out 4 fundamental CDD measures that licensed issuers must undertake. First, the issuer must identify the customer and subsequently verify that identity using reliable independent source documents, data, or information. Second, any beneficial owners of the customer must be identified, and reasonable measures must be taken to verify their identities. The third obligation is to obtain information on the purpose and intended nature of the business relationship, unless that purpose is self-evident. Finally, if a person purports to act on behalf of a customer, that person's identity and authority to act must be identified and verified. As to the specifics of identification and verification, for a natural person, the licensed issuer is required to verify the person's full name, date of birth, nationality, residential address, and unique identification number, for example, their ID card number or their passport, and document type by obtaining photo-bearing documents such as Hong Kong ID cards or passports or other documents issued by reliable and independent sources. For a legal person, such as a company, the requirements include verifying its full name, date and place of incorporation, registered office address, its unique identification number, such as a BR, business registration number or incorporation number, current existence and powers that regulate it using reliable documents such as records of registration, a certificate of incorporation or partnership agreement. The guideline has specific requirements for non-face-to-face customer onboarding. When a licensed issuer's business model involves identifying and verifying a natural person through a remote channel, such as a mobile application or the internet, the guideline requires it to either verify the customer's identity using data or information provided by a reliable independent digital identification system that has been formally recognized by the HKMA, or use appropriate technology that is capable of ensuring the authenticity of the documents, data, or information submitted electronically, and of incontrovertibly linking the natural person customer to the authenticated identity document. In addition, licensed issuers must obtain supplementary customer information to manage the specific risks associated with remote delivery. This includes, but is not limited to, IP addresses with associated timestamps, geolocation data, unique device identifiers, and, where applicable, wallet addresses and transaction hashes. For any customer that is a legal person, a licensed issuer is required to identify all of its connected parties by obtaining their names. This includes individuals such as the directors of a corporate customer. If a connected party is also a customer, a beneficial owner of a customer, or a person purporting to act on behalf of a customer, the licensed issuer must also identify and verify that person's identity in accordance with the guideline. A licensed issuer must identify and verify the identity of the beneficial owner or owners of a customer that's a legal person. A beneficial owner is the natural person who ultimately controls or owns the customer or on whose behalf the transaction is being conducted. This means identifying any natural person, i.e. an individual, with a controlling ownership interest, which is defined as more than 25%, or who exercises control over its management. If there's no such person, the licensed issuer must identify and verify the identity of the senior managing officials. The licensed issuer must also understand the customer's ownership and control structure and obtain sufficient information to satisfy itself that there are legitimate reasons for any complexity in the structure. For any person purporting to act on a customer's behalf, the licensed issuer must conduct the identity and identity verification procedures required for a natural person, and must additionally verify the person's authority to act on its behalf by obtaining documentary evidence such as a board resolution. The extent of the customer due diligence to be conducted on a customer must be determined using a risk-based approach so that it is proportional to the money laundering and terrorist financing risks associated with particular customers. Enhanced due diligence complying with the requirements of Section 15 of Schedule 2 to the AMLO is required for cases involving a high risk of money laundering or terrorist financing. While simplified due diligence complying with the requirements of Section 4 of Schedule 2 to the AMLO can be applied in low-risk scenarios, provided that the level of due diligence aligns with the identified risks and is supported by thorough risk analysis. Simplified due diligence cannot be used if the risk assessment changes to indicate higher risks, if money laundering or terrorist financing is suspected, or if there are doubts about previously obtained identification documents or information. A licensed issuer must also obtain senior management approval for initiating or continuing any business relationships presenting a high risk of money laundering or terrorist financing. A licensed stablecoin issuer must establish and maintain effective procedures for determining whether a customer or a beneficial owner of a customer is a politically exposed person or PEP. This determination encompasses non-Hong Kong PEPs, Hong Kong PEPs, and international organization PEPs, the definitions of which are set out in the guideline. Where a customer or a beneficial owner of a customer is identified as a non-Hong Kong PEP, politically exposed person, the licensed issuer must take reasonable measures to establish their source of wealth and source of funds before establishing a business relationship or before continuing an existing business relationship where the individual's PEP status is discovered later. Senior management approval is also required for establishing or continuing the business relationship. These requirements also apply to Hong Kong PEPs and international organization PEPs when the issuer identifies a higher risk of money laundering or terrorist financing in the context of a business relationship with them. In the case of former PEPs, licensed issuers can discontinue the enhanced measures if they conclude that the individual no longer presents a high money laundering or terrorist financing risk after conducting an assessment. Licensed issuers must also apply enhanced due diligence measures to business relationships and transactions with natural and legal persons from jurisdictions for which these measures are required by the Financial Action Task Force or the HKMA. Where a licensed stablecoin issuer appoints a third-party entity to distribute its specified stablecoins, it must treat the distributor as its customer, conduct customer due diligence on it, and apply a series of additional due diligence measures, guided by a risk-based approach. This additional due diligence requires the issuer to first collect sufficient information to fully comprehend the nature of the third party's business operations. Secondly, it must determine from publicly available information the entity's reputation and the quality and effectiveness of the AML-CFT regulation and supervision in its operating jurisdiction. Finally, the issuer must assess the third party's internal AML-CFT controls and be satisfied that they're adequate and effective in mitigating the attendant risks. If a licensed issuer can't satisfactorily complete CDD, it is prohibited from establishing a business relationship and from carrying out an occasional transaction with the customer. If a business relationship already exists, the licensed issuer must terminate it as soon as reasonably practicable. In these situations, the issuer is also required to consider whether the circumstances warrant filing a suspicious transaction report with the Joint Financial Intelligence Unit. A unique aspect of the guideline is its focus on wallet risk management, which extends beyond traditional CDD. The guideline requires licensed stablecoin issuers to manage the money laundering and terrorist financing risks associated with the wallets their customers use to receive specified stablecoins on issue, or to return them to the licensed issuer on redemption. Where a licensed issuer does not provide custodial services itself, holders of its specified stablecoins will have to hold them in custodial wallets provided by custodial wallet providers, which may be financial institutions or virtual asset service providers, which I'll refer to as VASPs, or in unhosted wallets, which are also commonly referred to as self-hosted or self-custody wallets. The key characteristic of an unhosted wallet is that its private key is held and controlled by the wallet's owner. A significant regulatory concern pertaining to unhosted wallets is that they enable peer-to-peer transfers of virtual assets without the involvement of an intermediary entity that is subject to AML and CFT obligations, which can be attractive to illicit actors or money launderers. Under the guideline, a licensed stablecoin issuer must identify each customer's wallet address and verify that the customer owns or controls it. To confirm ownership, the guideline suggests performing a micropayment test or a message signing test, or obtaining documentary evidence such as statements of account from the custodial wallet provider. The next due diligence steps depend on the type of wallet being used. If a customer's wallet is provided by a custodial wallet provider or is a self-hosted wallet used by a financial institution or VASP to hold their customers' stablecoins, the licensed issuer must conduct due diligence on the custodial wallet provider or self-hosted wallet provider. The required due diligence includes collecting information to understand the nature of their business, assessing from publicly available information their reputation and the quality of AML CFT regulation and supervision to which they're subject in the jurisdictions they operate in, and evaluating the adequacy and effectiveness of their AML and CFT controls. The extent of due diligence needs to be determined using a risk-based approach. The guideline notes, however, that these due diligence measures do not need to be repeated for every transfer on issuance or redemption for the same wallet addresses unless there is suspicion of money laundering or terrorist financing, or the issuer becomes aware of heightened risks associated with the wallet service provider through ongoing monitoring. For the highest risk scenario, where a customer uses an unhosted or self-custody wallet, other than one owned by a financial institution or VASP, to receive or return specified stablecoins, the licensed issuer is required to screen the wallet address to identify any transactions directly or indirectly associated with illicit or suspicious activities or sources, or designated parties. If screening indicates a higher risk of money laundering or terrorist financing, the issuer must implement additional control measures before proceeding with the issuance or redemption of specified stablecoins, such as enhanced monitoring of stablecoin transfers involving the unhosted wallet or the imposition of transaction limits. Screening of wallet addresses is also required if the due diligence on a customer's wallet with a custodial wallet provider cannot be satisfactorily completed because the wallet provider is not subject to AML and CFT regulation. To allow wallets to be quickly identified, the guideline allows a licensed issuer to keep a list of customers' wallet addresses that have undergone all the required procedures. Licensed stablecoin issuers are required to implement measures for ongoing monitoring to prevent stablecoins, including stablecoins in the secondary market, being used for illicit purposes. The approach to monitoring suspicious activities must be tailored to the licensed stablecoin issuer's specific business activities, operating structure, and corresponding money laundering and terrorist financing risks. Licensed issuers must continuously monitor their business relationships with customers in two key ways. First, they're required to conduct ongoing customer due diligence, which must include reviews of customer documents, data and information previously obtained to ensure they remain up to date and relevant. Issuers' policies and procedures must set out how frequently these reviews are required to be conducted and must specify other trigger events for the conduct of reviews. Secondly, listed issuers are required to conduct transaction monitoring, which requires scrutinizing customer transactions to check for transactions that are not compatible with the client's business, risk profile, and source of funds. Steps should also be taken to identify and document transactions that are complex, unusually large, or exhibit unusual patterns or lack an apparent economic or lawful purpose. Where the licensed issuer identifies transactions that exhibit these red flags or transactions involving wallet addresses linked with illicit or suspicious activities or persons, they are required to take appropriate steps, such as examining the background and purpose of the transaction or obtaining additional customer due diligence to identify whether there are grounds for suspicion. The guideline additionally requires licensed issuers to implement effective risk-based transaction monitoring systems at issuance and redemption of specified stablecoins to enable them to identify and report suspicious transactions. They must additionally put in place systems and controls, including appropriate technologies such as blockchain analytic tools, to screen transfers of specified stablecoins to and from customers and associated wallet addresses. The technology adopted must also enable licensed issuers to track stablecoins' transaction history and detect the destination of stablecoin transfers on issuance and the source of stablecoin transfers on redemption. It must also enable licensed issuers to identify transfers involving wallet addresses associated with illicit or suspicious activities or designated parties. Licensed stablecoin issuers remain fully responsible for AML/CFT compliance when using third-party technology solutions to screen stablecoin transactions and the associated wallet addresses. Accordingly, before implementing the technology, issuers must conduct thorough due diligence on the solution's effectiveness, data quality, that is, the coverage, accuracy, and reliability of the underlying database, and its limitations, for example, limited reach of the blockchain analytical tools or inability to handle wallet addresses that use anonymity-enhancing technology. Stablecoin issuers must also monitor additional data, including IP addresses with timestamps, geolocation data, device IDs, and metadata to identify suspicious activities. If monitoring measures reveal heightened risks of money laundering or terrorist financing, licensed stablecoin issuers must apply enhanced due diligence measures and ongoing monitoring measures and take additional risk mitigation or preventative measures. Licensed stablecoin issuers are required to implement adequate and proportionate ongoing monitoring measures to prevent the stablecoins that are in circulation from being used for illicit purposes. The guideline notes that the inherent traceability of on-chain stablecoin transactions recorded on the blockchain may assist in identifying illicit activities and associated wallet addresses. Stablecoin issuers can use various measures to counter the risk of stablecoins being used for illicit purposes, including using technological solutions such as blockchain analytic tools to screen stablecoin transactions and associated wallet addresses beyond the initial distribution on an ongoing basis, blacklisting wallet addresses identified as sanctioned or linked to illicit activities, and freezing the stablecoin if requested by a regulator, law enforcement authority, or court order. As it is currently uncertain whether these measures can effectively mitigate money laundering and terrorist financing risks, the HKMA requires stablecoin issuers to adopt a cautious approach in assessing whether their systems sufficiently mitigate these risks, particularly for peer-to-peer transfers between unhosted wallets. Unless a licensed stablecoin issuer can prove to the HKMA's satisfaction that these risk mitigating measures effectively prevent money laundering, terrorist financing, and other crimes, the stablecoin issuer must verify the identity of each stablecoin holder, even if there's no customer relationship between them. Alternatively, a stablecoin holder's identity can be verified by a regulated financial institution or VASP, or by a reliable third party. Stablecoin issuers must conduct further investigation into any illicit or suspicious activity and report any transactions suspected to involve money laundering or terrorist financing to the Joint Financial Intelligence Unit and take suitable follow-up actions as required by Chapter 8 of the Guideline. Chapter 6 of the Guideline sets out guidance for licensed issuers on how they should comply with the travel rule, that is, the requirements of Section 13A of Schedule 2 to the AMLO, where a transfer of specified stablecoins issued by the licensed issuer is within the definition of stablecoin transfer set out at paragraph 6.3 of the guideline. A transfer of a specified stablecoin will be within the definition if it is a specified stablecoin transfer by an ordering institution on behalf of an originator to a recipient at a beneficiary institution, whether or not any intermediary institutions are involved in the transfer. A licensed issuer may act as an ordering institution, a beneficiary institution, or an intermediary institution, depending on its business model, and must observe the relevant requirements set out in the guideline according to its role. Where a licensed stablecoin issuer acts as an ordering institution before performing a stablecoin transfer, it must obtain and record information regarding the originator and the recipient. The required information comprises their name, the number of the account or wallet address with the ordering or beneficiary institution from or to which the stablecoin transfer will be made, or if there's no such account, the unique reference number assigned to the stablecoin transfer by the ordering or beneficiary institution. Where the stablecoin transfer involves 8,000 Hong Kong dollars or more, the stablecoin issuer must also obtain the originator's address, customer identification number or ID number, and in the case of an individual, their date and place of birth. For stablecoin transfers involving 8,000 Hong Kong dollars or more, the licensed stablecoin issuer must verify the originator's identity and ensure the accuracy of the required information about the originator, which means that the information must be verified as part of the stablecoin issuer's CDD process. For an occasional stablecoin transfer involving less than 8,000 Hong Kong dollars, verification of the originator's identity is required only if there are several linked transactions that together exceed 8,000, or there is suspicion of money laundering or terrorist financing. There is no obligation on the ordering institution to ensure the accuracy of the required originator information. Ordering institutions must submit the required originator and recipient information to the beneficiary institution before or at the same time as the stablecoin transfer. The ordering institution must ensure that the required information is stored and submitted securely, that is, in a manner that ensures its integrity and protects it from unauthorized disclosure. The required information can be sent directly or indirectly, and it does not need to be attached to or included in the stablecoin transfer itself. To ensure safe transfer of the information, ordering institutions must conduct counterparty due diligence to confirm that the beneficiary institution and any intermediary institutions can protect data confidentiality and integrity and implement other appropriate safeguards, such as entering into formal agreements with counterparties or solution providers specifying data protection responsibilities, using strong encryption during data transmission, and adopting robust information security controls against unauthorized access or alteration. An ordering institution must not proceed with a stablecoin transfer unless it can guarantee secured data submission based on these safeguards and counterparty due diligence findings. Ordering institutions must keep records demonstrating their compliance with the requirements for submitting the required originator and recipient information to the beneficiary institution and provide these to the authorities when required. Intermediary institutions must retain all originator and recipient information associated with stablecoin transfers and transmit this complete dataset intact to the next institution in the chain, whether that is another intermediary or the beneficiary institution. The requirements for the immediate secure submission of required information by ordering institutions, which I just talked about, apply equally to intermediary institutions' onward transmission of the information. Intermediary institutions are also required to conduct counterparty due diligence on the ordering institution and any other intermediary institutions, and must comply with the same record-keeping requirements as apply to ordering institutions. Beneficiary institutions must obtain and record all required originator and recipient information submitted to them in relation to stablecoin transfers. They are also required to conduct stablecoin transfer counterparty due diligence measures on the ordering institution and any intermediary institutions. For transfers involving 8,000 Hong Kong dollars or more, beneficiary institutions must additionally verify the recipient's identity, if not previously verified by their customer due diligence process, and cross-check the recipient's name and account number provided against their own records and take reasonable risk mitigation measures if discrepancies are found. Beneficiary and intermediary institutions must establish procedures to identify and handle stablecoin transfers that do not provide the required originator or recipient information. These procedures must include monitoring measures to detect non-compliant transfers with missing information, risk-based protocols for determining whether and when to execute, suspend, or return stablecoin transfers with missing data, and take other appropriate actions. Steps to obtain missing information from the sending institution, and if the information is not provided, either restricting or terminating the business relationship with the ordering or intermediary institution involved, or taking reasonable measures to mitigate the risks of money laundering and terrorist financing. When provided with incomplete or meaningless originator or recipient information, beneficiary and intermediate institutions must implement risk mitigation actions in accordance with their established procedures. Where licensed stablecoin issuers use technological solutions to comply with the travel rule, they remain ultimately responsible for compliance. Before using a technological solution, a licensed issuer must conduct due diligence to confirm the solution's ability to ensure the issuer's travel rule compliance. This requires confirming that the solution can identify stablecoin transfer counterparties, that is, the ordering intermediary or beneficiary institution, which is the counterparty to a stablecoin transfer involving a licensed stablecoin issuer. The licensed issuer's due diligence on the technology solution also needs to confirm that it can submit required information immediately and securely, receive required information, and detect whether the required information provided by ordering institutions is incomplete or missing. Licensed stablecoin issuers should also consider various other factors, including whether the technology is compatible with systems used by their counterparties, can transmit and obtain the required information immediately and securely at scale across multiple counterparties, and whether it allows effective suspicious transaction monitoring and sanctions compliance, including the freezing of prohibited transfers. Other considerations are whether the technology facilitates stablecoin transfer counterparty due diligence and supplemental information requests, and supports proper record keeping of the required information. If a licensed issuer opts to use a technological solution for travel rule compliance, it should keep records of its due diligence on the technological solution. The guideline notes that licensed stablecoin issuers conducting stablecoin transfers may be exposed to money laundering and terrorist financing risks associated with their stablecoin transfer counterparties. As I just mentioned, the term stablecoin transfer counterparty refers to the ordering intermediary or beneficiary institution, which is the counterparty to a stablecoin transfer. The extent of the risks will depend on the counterparty's customer types, geographic exposure and operational jurisdictions, and the adequacy of AML and CFT controls in those jurisdictions. To ensure compliance with AML and CFT requirements and the travel rule, licensed stablecoin issuers are required to conduct due diligence on stablecoin transfer counterparties before executing stablecoin transfers. For stablecoin transfer counterparties based in different jurisdictions but belonging to the same corporate group, the guideline requires due diligence to be conducted on the counterparties as independent entities, but also requires an assessment of the counterparties as a group to assess the money laundering and terrorist financing risks they pose. Where money laundering or terrorist financing risks are identified, licensed issuers must apply appropriate AML-CFT measures. Counterparty due diligence is required for the first stablecoin transaction with the counterparty, but repeated due diligence is generally not required unless the licensed stablecoin issuer suspects money laundering or terrorist financing or is aware of heightened risks of money laundering or terrorist financing from its ongoing monitoring of stablecoin transfers with the counterparty. Counterparty due diligence is required to determine whether the transaction involves a stablecoin transfer counterparty or an unhosted wallet. Identify the stablecoin transfer counterparty by reference to lists of licensed or registered financial institutions or VASPs, and assess whether the stablecoin transfer counterparty is an eligible counterparty to deal with, and send the required originator or recipient information to. The licensed issuer's due diligence on a stablecoin transfer counterparty should involve verifying its identity using documents provided by a reliable independent source and reasonable steps to understand its ownership and control structure. The licensed issuer should also collect information enabling it to understand the nature of the counterparty's business, analyze transaction characteristics and projected transaction volumes to ascertain the risk profile of expected transfers, and assess the counterparty's reputation and the quality of the AML-CFT regulation and supervision to which it is subject. Other due diligence measures should include evaluating the sufficiency of the counterparty's AML-CFT controls and obtaining senior management approval. Licensed stablecoin issuers' due diligence must also assess whether a stablecoin transfer counterparty is able to comply with the travel rule, taking into account whether the counterparty is subject to requirements comparable to the travel rule in the jurisdictions in which it operates, and whether the counterparty's AML-CFT controls are effective in ensuring compliance with the travel rule or comparable requirements. Stablecoin issuers should additionally assess whether the counterparty's data privacy and security controls can sufficiently protect the originator and recipient information. The guideline sets out factors that are considered to indicate that a stablecoin transfer counterparty may pose higher risks of money laundering and terrorist financing. These include whether the counterparty operates or is incorporated in a high-risk jurisdiction or one known to have weak AML-CFT regulation, or is not a regulated entity subject to AML-CFT regulation and supervision. Other factors indicative of higher risks are the counterparty's failure to maintain adequate AML-CFT systems, including measures for ensuring travel rule compliance, failure to implement sufficient data protection safeguards to ensure the confidentiality and integrity of personal information, associations with money laundering, terrorist financing, or other illicit activities. The guideline also requires licensed stablecoin issuers to monitor their stablecoin transfer counterparties on an ongoing basis to detect suspicious activities and assess evolving risks. This requires them to adopt a risk-based approach to the monitoring of stablecoin transfers to detect unusual activities or transactions or changes in counterparties' risk profiles. Licensed issuers must additionally review the information obtained from their initial due diligence exercise on a regular basis and on the occurrence of a trigger event, such as a sanctions listing, investigation for money laundering, or terrorist financing or other regulatory action. Based on the results of its due diligence, a licensed stablecoin issuer must make risk-sensitive determinations about whether to continue to transfer stablecoins and required information to stablecoin transfer counterparties and the level of AML-CFT measures to apply. Upon identifying money laundering or terrorist financing risks through counterparty due diligence, licensed stablecoin issuers must evaluate the potential impact of these risks on their operations and implement proportionate risk management and mitigation measures. These measures can include conducting enhanced or more frequent due diligence reviews, closely monitoring relevant stablecoin transfers, and imposing transaction limits. Licensed stablecoin issuers must continuously assess whether to maintain, restrict, or terminate relationships with high-risk counterparties. If the money laundering and terrorist financing risks presented by a stablecoin transfer counterparty can't be effectively mitigated, the issuer must refrain from executing or facilitating any stablecoin transfers involving the relevant counterparty. Specifically, under no circumstances may HKMA licensed stablecoin issuers conduct stablecoin transfers with shell VASPs or shell financial institutions. Licensed stablecoin issuers must implement enhanced controls for stablecoin transfers to and from unhosted wallets. Before executing a transfer to or from an unhosted wallet for the first time, a licensed stablecoin issuer must obtain and record information regarding the originator and the recipient. For a stablecoin transfer to an unhosted wallet, the required information comprises the originator's name, its account number with the licensed stablecoin issuer, or the unique reference number assigned to the transfer by the stablecoin issuer, the originator's address, customer ID number or identification number, or if the originator is an individual, their date and place of birth and the recipient's name and wallet address. For transfers from an unhosted wallet, the stablecoin issuer must obtain the originator's name, wallet address, and customer identification number or identification document number, or if the originator is an individual, their date and place of birth. It also has to obtain the recipient's name and its account number with the stablecoin issuer or the unique reference number assigned to the stablecoin transfer by the stablecoin issuer. The originator's address, ID number, and date and place of birth are not required for transfers involving less than 8,000 Hong Kong dollars. Licensed issuers are not required to obtain originator and recipient information for peer-to-peer stablecoin transfers between unhosted wallets held by persons who are not customers of the issuer. They must, however, comply with the requirements for the ongoing monitoring of stablecoins circulating in secondary markets, which I talked about earlier. Licensed stablecoin issuers must implement controls to ensure compliance with relevant legal and regulatory requirements on terrorist financing, financial sanctions, and proliferation financing, and must provide training to staff to ensure they understand their legal and regulatory obligations and those of the issuer. To allow them to identify terrorist suspects and designated parties and detect prohibited transactions, issuers must maintain a database consolidating the names and particulars of terrorists and designated parties and countries, individuals and entities included in relevant lists. The database must include lists published in the Hong Kong Gazette or on the Commerce and Economic Development Bureau website, any United Nations Security Council resolutions and sanctions list related to terrorism, terrorist financing and proliferation financing, and lists specified by the HKMA. The database must be promptly updated whenever changes occur and be readily accessible to relevant staff. Licensed stablecoin issuers can subscribe to a third-party service provider's database but must implement appropriate measures such as periodic sample testing to ensure its completeness and accuracy. A stablecoin issuer can also delegate the maintenance of the database or the screening process to its overseas office. However, the ultimate responsibility for ensuring full compliance with relevant regulations and legislation remain with the stablecoin issuer. Licensed stablecoin issuers must implement an effective screening mechanism to prevent establishing business relationships or conducting transactions with terrorist suspects and other prohibited parties, including designated persons or entities, anyone acting on their behalf or at their direction, and entities owned or controlled by any of these parties. Screening must be conducted irrespective of the customer risk profile. Issuers are required to screen customers and their beneficial owners against the current database on issuing and redeeming stablecoins and against any new or updated designations as soon as practicable. They should additionally apply a risk-based approach to screening connected parties of customers and persons purporting to act on behalf of a customer. Parties to a stablecoin transfer must be screened against the current database before the transfer is executed. If an incoming stablecoin transfer occurs without prior screening, or if any required originator or recipient information is missing, stablecoin issuers must implement appropriate risk mitigation measures, such as preventing the stablecoins being made available to the recipient until screening is satisfactorily completed, and document the measures taken. When screening identifies possible name matches, stablecoin issuers must conduct enhanced investigation to confirm if they are genuine hits and document all relevant records and results. Where there are suspicions of terrorist financing, proliferation financing, or sanctions violation, licensed stablecoin issuers must make a report to the Joint Financial Intelligence Unit in Hong Kong. Records of enhanced checking results and screening are required to be documented or recorded electronically. If a licensed stablecoin issuer relies on its overseas office to maintain the database or perform the screening process, it will remain primarily responsible for ensuring compliance with relevant laws and regulations on terrorist financing, financial sanctions, and proliferation financing activities. Licensed stablecoin issuers have a statutory obligation under Section 25A1 of the Drug Trafficking Recovery of Proceeds Ordinance, the Organised and Serious Crimes Ordinance, and Section 12.1 of the United Nations Anti-Terrorism Measures Ordinance to file a suspicious transaction report with the Joint Financial Intelligence Unit if they know or suspect that any property represents the proceeds of drug trafficking or an indictable offence, whether in whole or in part, and whether directly or indirectly, was used or is intended to be used in connection with those offences or constitutes terrorist property. Failure to report carries a maximum penalty of 3 months in prison and a 50,000 Hong Kong dollar fine. Revealing information to other persons that might prejudice an investigation, including internal suspicions not yet reported, constitutes the criminal offence of tipping off. Accordingly, notifying a customer of a suspicious transaction report filing is strictly prohibited. However, legitimate customer inquiries made in good faith are permitted to the extent they do not tip off the customer. To ensure compliance with their statutory reporting obligations and manage relevant risk, stablecoin issuers must implement AML-CFT systems that include appointing a money laundering reporting officer as the main point of contact for internal reporting of suspicious transactions and for communications with the Joint Financial Intelligence Unit and enforcement authorities. AML-CFT systems are also required to include policies and procedures for internal reporting, reporting to the JFIU, post-reporting risk mitigation, and preventing tipping off. They should also cover providing guidance to staff on detecting suspicious circumstances and recognizing indicators of money laundering and terrorist financing. Stablecoin issuers must monitor their AML-CFT systems on suspicious transaction reporting on an ongoing basis to ensure they meet regulatory requirements and are effective. Suspicious transaction reports must be filed with supporting information as soon as is reasonably practicable after the knowledge or suspicion arises, and should be of high quality, incorporating feedback from the Joint Financial Intelligence Unit and the HKMA. After filing a suspicious transaction report, licensed stablecoin issuers must conduct an immediate review of the relevant business relationship, implement risk mitigating measures, such as freezing stablecoins if required to do so by law enforcement agencies, and only continue the relationship if adequate risk mitigation and controls are in place. Where necessary, the case should be escalated to senior management to determine how to mitigate legal or reputational risks and the stablecoin issuer's capacity to mitigate the identified risks. Licensed stablecoin issuers must establish clear policies and procedures to respond to law enforcement agencies' requests, for example, search warrants and production restraint and confiscation orders, effectively and promptly. This includes allocating sufficient resources and designating a dedicated point of contact. When receiving crime-related requests regarding a customer or business relationship, stablecoin issuers must promptly assess the risks involved and review the business relationship to determine whether there's any suspicion of money laundering or terrorist financing, while keeping in mind that the customer may be a victim rather than a suspect. Licensed stablecoin issuers must maintain comprehensive records, both to assist in the investigation and prosecution of criminal and terrorist offences and to demonstrate their compliance with the AMLO, the guideline and HKMA directives. Issuers must retain customer due diligence information, stablecoin transaction records, and other documents required to meet relevant regulatory obligations. A stablecoin issuer must ensure that its records create a clear and complete audit trail for all the funds it handles in relation to customers and stablecoin transactions, and that all CDD information and stablecoin transaction records can be quickly produced to its auditors, the HKMA, and other relevant authorities. These records should also demonstrate the issuer's compliance with the record-keeping requirements of Sections 20 and 21 of Schedule 2 to the AMLO, the guideline and other relevant HKMA guidelines. Stablecoin issuers must keep the required records for at least 5 years after completion of the relevant transaction, regardless of whether the transaction is an occasional transaction and of whether the business relationship will terminate during the period. Where the transaction is made with a person with whom the stablecoin issuer has a business relationship, there is an additional requirement that records are kept for a minimum of 5 years after the business relationship ends. Paragraph 9.4 of the guidelines sets out the documents and records that must be kept. They include originals or copies of documents and a record of data and information obtained when conducting customer DD, including when identifying and verifying the identity of customers, beneficial owners, persons purporting to act on behalf of the customer, and/or other connected parties of the customer, and when conducting ongoing customer DD and monitoring, stablecoin issuers must also retain original or copy documents and records of the purpose and nature of the business relationship, and documents relating to the customer's account and business correspondence with the customer and any beneficial owner that demonstrate the issuer's compliance with the AMLO. Records must also be kept of the results of any analysis undertaken, for example, inquiries to establish the background and purposes of transactions that are complex, unusually large in amount, of an unusual pattern, or that have no apparent economic or lawful purpose. Stablecoin issuers must retain the required originator and recipient information they obtain or receive as ordering institutions in complying with the travel rule for stablecoin transfers to and from institutional counterparties. They are also required to keep the required originator and recipient information they have to obtain under paragraph 6.41 in relation to stablecoin transfers to or from unhosted wallets of customer stablecoin holders. Issuers must retain the original of any document or keep a copy on microfilm or in a computer database. Records consisting of data or information must be stored on microfilm or in a computer database. Regardless of the medium or location of CDD and stablecoin transaction records, record keeping must comply with the requirements of Schedule 2 to the AMLO. Stablecoin issuers are required to maintain a register of all money laundering and terrorist financing reports submitted to the Money Laundering Reporting Officer, which should include the reporting staff, staff involved in handling the report, assessment outcomes, whether a suspicious transaction report is subsequently filed with the JFIU, and information to enable the location of relevant documents. A register of suspicious transaction reports filed with the JFIU must also be maintained, containing the report dates, names of the reporting staff members, and information to enable relevant documents to be located. These two registers may be consolidated where operationally appropriate. If customer identification and verification documents are held by an intermediary that a licensed stablecoin issuer relies on for conduct of CDD, the stablecoin issuer remains responsible for ensuring compliance with the record-keeping requirements. Accordingly, stablecoin issuers must ensure that any intermediary to which they outsource CDD maintains systems to comply with the record-keeping requirements of the AMLO and the guideline, and will provide documents and records to the stablecoin issuer promptly upon request. The guideline additionally requires that if a stablecoin issuer relies on an intermediary to perform CDD, it must immediately obtain the data and information collected by the intermediary, and must also ensure that the intermediary will transfer all documents and records to the stablecoin issuer on termination of the intermediary's services. Turning now to the licensing application process for a stablecoin issuer license under the ordinance, this is a structured multi-step procedure. Prospective applicants are encouraged to begin with an informal preliminary consultation with the HKMA's licensing team to allow them to gain an understanding of the applicant's background and business model and enable the applicant to clarify the regulatory expectations before committing to a formal application. For applications whose parent company is regulated overseas, it's also crucial to consult with the relevant home regulator beforehand to prevent potential processing delays. The formal application requires the submission of an extensive set of documents as detailed in Annex B to the HKMA's explanatory note on licensing stablecoin issuers. This includes completed application forms for the license applicant, each chief executive and director, and in the case of a non-authorized institution, completed application forms for each controller and the stablecoin manager. Other documents required to be submitted include a 3-year business plan, detailed corporate and ownership structure, information, and a comprehensive suite of policies and procedures covering reserve asset management, risk frameworks, AML, CFT, and corporate governance that will enable the license applicant to comply with the requirements of the Supervision Guideline and AML CFT Guideline. During the processing phase, applicants should anticipate that the HKMA may request additional information and may require the submission of independent assessment reports to verify compliance with the regulatory requirements. A formal decision to grant a license, which may be subject to conditions, or to refuse the application, will be made after review by a Stablecoin Advisory Committee. The HKMA will only grant a license once it's satisfied that the applicant will be able to comply with all the minimum criteria set out in Schedule 2 to the Ordinance. Critically, entities must not publicly describe themselves as an applicant or behave in a manner suggesting they are an applicant until a formal application has been submitted to the HKMA, since this is an offence under Section 154 of the Stablecoins Ordinance. On granting a licence, the HKMA will provide the successful applicant with a formal written notice stipulating the assigned licence number and the official date on which the licence becomes effective. The HKMA will then update the public record by including the issuer's details and the official register of licensed stablecoin issuers, which is available on the HKMA website. This register is maintained by the HKMA in accordance with Section 21(2) of the Stablecoin Ordinance and serves to make the entity's license status publicly verifiable. Once granted, a stablecoin issuer license remains in force until revoked. Where a license application is refused, the HKMA must issue a written notice to the applicant that details its decision and the grounds for the refusal. A decision of the HKMA to reject a license application can be appealed to the Stablecoin Review Tribunal. I'm now going to look at the second major activity regulated by the Stablecoin Ordinance, the offering of specified stablecoins. Under Section 9 of the Stablecoins Ordinance, only specified stablecoins issued by an HKMA licensed issuer can be offered to the Hong Kong public. In addition, these offers can only be made by permitted offerors, which are a limited list of entities that are themselves regulated by the HKMA or the SFC. They include a licensed stablecoin issuer, which can offer its own or another HKMA licensed issuer's specified stablecoins, virtual asset trading platforms licensed by the SFC under the AMLO, a stored value facility licensed under Payment Systems and Stored Value Facilities Ordinance, an SFC licensed corporation with a Type 1 dealing in securities license, or an HKMA authorized institution such as a bank. Under Section 6 of the Ordinance, a person is considered to offer a specified stablecoin if they make a communication in any form to another person that provides sufficient information as to the specified stablecoin being offered, the terms and conditions on which it's offered, and the channels through which it's offered, for them to decide whether to acquire the specified stablecoin. Specified stablecoins issued by unlicensed issuers, where the issue is not prohibited under Section 8 of the Ordinance, can be offered by permitted offerors only to professional investors as defined under the Securities and Futures Ordinance by virtue of the Stablecoins Ordinance specification of persons for Section 92B3 notice, which specifies professional investors as a class of investors to whom specified stablecoins can be offered under Section 92B of the Ordinance. Specified stablecoins can only be offered to professional investors under Section 92B if their issue does not breach Section 8 of the Ordinance. This means that the issue of the specified stablecoin must not constitute a regulated stablecoin activity, and so the specified stablecoin must not be issued in Hong Kong, and if issued outside Hong Kong, it must not reference the Hong Kong dollar. This provision allows permitted offerors to offer stablecoins issued outside Hong Kong that reference currencies other than the Hong Kong dollar to be offered to professional investors in Hong Kong. It therefore allows permitted offerors, such as licensed virtual asset trading platforms, to offer specified stablecoins, such as USDT, to professional investors on their platforms. Contravention of the restrictions on offering is a serious offence, carrying maximum penalties of a 5 million Hong Kong dollar fine and up to 7 years imprisonment, and a daily fine of 100,000 Hong Kong dollars for every day the offence continues. The offence under Section 9 covers both actual offering of specified stablecoins and holding oneself out as offering specified stablecoins in breach of the applicable restrictions. Holding out additionally covers the act of actively marketing to the Hong Kong public that a person conducts an activity elsewhere which would constitute the offering of a specified stablecoin if conducted in Hong Kong. This prevents an offshore offeror of specified stablecoins from actively marketing its services to the Hong Kong public. In a further display of its regulatory reach, the HKMA has the power to formally classify an overseas entity as a designated stablecoin entity under Section 101 of the Stablecoins Ordinance. This power applies to overseas entities that carry on a business of issuing specified stablecoins not pegged to the Hong Kong dollar outside Hong Kong, or provide services to a stablecoin payment system regardless of the location of the stablecoin payment system. The HKMA can only designate an entity if it is of the opinion that the entity's activities are or are likely to become material to the monetary or financial stability of Hong Kong, or to its functioning as an international financial centre, or if there are matters of significant public interest. A designated stablecoin entity must comply with certain requirements set out in Section 107 of the Ordinance. These include requirements that the designated stablecoin entity must have operating rules that comply with HKMA regulations, provide for the entity to be operated in accordance with the Stablecoins Ordinance, and provide appropriate and adequate arrangements to deal with the situation where the entity is likely to become unable to meet its debts. A designated entity must also maintain appropriate and adequate financial resources and have in place and implement appropriate and adequate systems of control for reserve management, disclosures and risk management in relation to its issue of specified stablecoins or provision of services to a stablecoin payment system, as the case may be. Failure to comply with the requirements of Section 107 is an offence which carries a maximum fine of 400,000 Hong Kong dollars. By granting the HKMA this authority, the Ordinance provides leverage to ensure that any major offshore player whose activities could pose a systemic risk to Hong Kong must either obtain a full licence or face formal designation, thereby becoming subject to the regulatory requirements of Section 107. It's an offence under Section 10 of the Stablecoins Ordinance to publish an advert that holds a person out as carrying on a regulated stablecoin activity if that person is not licensed by the HKMA or exempted from the licensing requirement. Section 10 also makes it an offence to publish an advert that holds a person out as offering a specified stablecoin if that person is not permitted to offer specified stablecoins under Section 9.2 of the Stablecoins Ordinance. An advert for these purposes is broadly defined to include all forms of advertising, whether oral, electronic or optical. The offence carries maximum penalties of 6 months imprisonment and a 50,000 Hong Kong dollar fine. Section 11 of the Stablecoin Ordinance establishes a criminal offence for fraudulent or deceptive conduct in any transaction involving a specified stablecoin. A person is liable if they directly or indirectly either employ any device, scheme or artifice with intent to defraud or deceive, or engage in any act, practice or course of business that is fraudulent or deceptive, or that would operate as a fraud or deception. On conviction, this offence carries maximum penalties of a 10 million Hong Kong dollar fine and 10 years imprisonment, and the courts can also prohibit offenders from engaging in stablecoin-related transactions for up to 5 years. It's also an offence under Section 12 of the Ordinance for a person to make a fraudulent or reckless misrepresentation for the purpose of inducing someone to enter into an agreement to acquire, dispose of, subscribe for, or underwrite a specified stablecoin. The offence carries severe penalties, 7 years in prison and a 1 million Hong Kong dollar fine, highlighting the critical importance of ensuring that all communications relating to specified stablecoins are accurate and verifiable. Sections 154 and 155 of the Ordinance address false representations about licensing status at the application and licensing stages and cover both express statements and implied conduct. Section 154 prohibits a person who's not an applicant from describing themselves in whatever terms as an applicant for a license. It also prohibits behaving or otherwise holding oneself out in a manner that indicates or is reasonably likely to be understood as indicating that the person is a licensed applicant. Section 155 prohibits a person who is not a licensed issuer under the Ordinance from describing themselves as such and from behaving or otherwise holding themselves out in a manner that indicates or is reasonably likely to be understood as indicating that the person is a licensed issuer. The maximum penalties for these offences are $400,000 fines and 2 years imprisonment, plus a further 10,000 Hong Kong dollars per day for a continuing offence. Part 8 of the Ordinance contains various general offences. Section 149 of the Stablecoin Ordinance makes it an offence to provide false or misleading information to the HKMA, regardless of whether the information is provided voluntarily or in compliance with a requirement. A person commits the offence if they know or ought reasonably to know that they are providing information, including documents, representations, or statements, whether written or oral, that are false or misleading in a material particular, or if they omit a material particular that renders the information false or misleading. Representation encompasses facts, future events, and states of mind. Penalties on conviction include, on summary conviction, a fine at level 6 and imprisonment for up to 6 months, or on conviction on indictment, a fine of up to 1 million Hong Kong dollars and imprisonment for up to 2 years. It's also an offence under Section 150 to sign false or misleading books, accounts, or documents that are produced to the HKMA. Under Section 153, it's an offence to willfully make false entries, omissions, or alterations in books of record or relevant documents related to a regulated stablecoin activity with intent to deceive. The HKMA can revoke a stablecoin issuer's license on various grounds, which are set out in Schedule 4 to the Stablecoins Ordinance. These include failure to comply with any of the minimum criteria set out in Schedule 2 to the Ordinance, breach of any condition attached to an issuer's license, entering into or proposing arrangements with creditors, such as compositions, voluntary arrangements under the Bankruptcy Ordinance, or facing insolvency, winding up, or dissolution, notifying the HKMA of impending inability to meet obligations, insolvency, payment suspension, or business activity cessation, or actual inability to fulfill obligations or suspension of payments or licensed activities. Other grounds for revocation include failing to provide the HKMA with information required to be provided under the Ordinance that's material in relation to the licensed issuer or its business methods, providing false, misleading, or inaccurate information at any stage, ceasing licensed business activities, and failing to pay prescribed license fees. So that brings me to the end of this webinar. Bye, and hope to see you again.